The International Court of Justice is based at the Peace Palace in The Hague, in the Netherlands. The court is one of the 6 principal organs of the UN. It's the principal judicial organ of the UN and the only principal organ which does not have its seat in New York. The court has existed since 1946. Its 2 official languages are French and English. Its statute, that is to say the founding document of the International Court of Justice, is an integral part of the Charter of the United Nations. All UN member states therefore automatically recognize the existence of the court and can call on its services. The establishment of the Permanent Court of International Justice, PCIJ, the predecessor of the ICJ, was provided for in the Covenant of the League of Nations. It held its inaugural sitting in 1922 and was dissolved in 1946. The International Court of Justice has 2 roles. The first is to decide disputes between states. We talk here about contentious cases. Since 1946, this kind of case has represented 80% of the work of the court.
Therefore, Georgia respectfully requests the court, as a matter of urgency, to order the following provisional measures.
Madam President, members of the court, I now have the honor to read out to you the final submission of the Russian Federation.
Le gouvernement de la République démocratique du Congo prie la Cour de dire et juger.
Voici les conclusions finales de la Belgique en la présente affaire.
Serbia requests the court to adjudge and declare.
The Republic of Croatia respectfully requests the International Court of Justice to.
Je vais maintenant lire les conclusions finales de la République du Bénin. La République du Niger prie la Cour de dire et juger que
Malaysia respectfully requests the court to adjudge and declare.
In accordance with Article 60, I hereby present Singapore's final submissions.
The final submissions of Colombia pursuant to Article 60 of the Rules of Court.
The Republic of Nicaragua respectfully requests to the court to adjudge and declare that
la République de Djibouti prie la Cour de dire et juger.
J'ai maintenant l'honneur de vous donner lecture des conclusions finales de la République française.
Mexico makes the following revised submissions.
The court should reject Mexico's request for provisional measures.
Its second role, to respond to legal questions submitted by the UN and its related organizations. In these cases, we speak of advisory proceedings. These represent 20% of the cases submitted to the court since 1946. Since it was set up, the court has handled altogether some 150 cases, including both categories. The ICJ is not a criminal court, and it does not try individuals. Only disputes between states can be submitted to it. It should not be confused with the international tribunals based at The Hague, such as the International Criminal Tribunal for the former Yugoslavia, ICTY, or the International Criminal Court, ICC. The ICTY and the ICC try individuals prosecuted for war crimes, crimes against humanity, and genocide. The ICJ, the ICTY, and the ICC are 3 completely independent institutions. The International Court of Justice consists of 15 judges. They're elected for 9 years by the UN General Assembly and the Security Council. 5 posts are renewed every 3 years. Judges can be re-elected for further terms of 9 years.
The results of the voting is as follows. Ballot results. Mohamed Benuna, Bernardo Sepulveda, Leonid Skotnikov, Thomas Bergenthal, Kenneth Kate.
The members of the court must each be from a different country. They do not represent their countries, they are independent judges. To become judges, candidates must have the qualifications required in their own countries for appointment to the highest judicial offices, or be jurisconsults of recognized competence in international law.
I solemnly declare that I will perform my duties and exercise my powers as judge, honourably, faithfully, impartially and conscientiously.
For a number of years, the composition of the court has maintained the following geographical balance. 5 seats on the bench are occupied by judges from Western Europe and other Western states. 3 seats are occupied by African judges. 3 others by Asian judges. 2 by judges from Eastern Europe, and 2 seats by judges from Latin America. Judges are elected on the basis of their individual quality. Although no country is entitled to a seat, there has always been one judge from each of the 5 permanent members of the Security Council. If in a particular case the court does not have a judge of the nationality of each of the states parties to the case, those states can each appoint what's called an ad hoc judge. These judges have exactly the same rights and duties as elected judges. Every 3 years, the court elects its president and vice president. The president chairs all sittings of the court. He or she directs its work and supervises its administration. The vice president replaces the president when there's a vacancy in the presidency or when the president is unable to act. The judges are assisted by a registrar. Elected by the court for a renewable term of 7 years, the registrar is the head of the court secretariat, its registry. He also performs the functions in relation to judicial matters delegated by the statute. The registrar runs a team of some 115 staff members of the registry recruited from all over the world. The court is administratively independent. It's the only principal organ of the United Nations not under the control of the UN Secretariat. The court's first role is to judge legal disputes between states. These contentious cases have represented 80% of its work since 1946. In the past, contentious cases have related typically to such classical interstate disputes as border disputes and maritime delimitation or diplomatic protection. Yet they have increasingly concerned, for example, topics such as international humanitarian law, international environmental law, the use of force, and the international responsibility of states. The court applies public international law, that is to say, customary international law and treaty law, which govern relations between states, and the general principles of law. The ICJ is open to all UN member states and other states parties to the statute of the court.
States are sovereign. They are free to choose the means for resolving their legal disputes. It is a basic principle of international law. The court is thus able to hear a case only if the states involved have freely consented to having the case referred to it. There are 3 principal ways in which they give such consent. Firstly, by entering into a special agreement, that is to say, a special treaty aimed at bringing a dispute between 2 or more states before the court. Secondly, by being party to 1 or more of some 300 treaties and accepting the compulsory clause attached thereto, providing for reference of cases to the court for the purpose of settling disputes concerning the interpretation or application of the treaty in question. Or third, by filing what is referred to as a unilateral declaration recognizing the compulsory jurisdiction of the court. These are specific instruments by which states may accept the compulsory jurisdiction of the court. To put it briefly, as a general rule, a state having thus recognized the court's compulsory jurisdiction is entitled to bring proceedings in the court against any other state having accepted the same obligation. And conversely, the state undertakes to appear before the court if proceedings are brought against it by another such state. In addition, in exceptional cases, one state may file an application against another inviting it to consent to the court's jurisdiction. If the second state does so, this situation is referred to as one of forum prorogatum. It is to be noted that by coming before the court of their own volition, states at the same time assume a commitment to comply with these decisions, which are binding. All judgments of the court are final and without appeal. If a state refuses to abide by a decision of the court, the opposing state may have recourse to the United Nations Security Council, which may, under Article 94 of the Charter, make recommendations or decide upon measures to be taken to give effect to the judgment. It is, however, extremely rare for this to happen, given the great legal, moral, and diplomatic authority with which decisions of the court are invested.
The court has delivered over 100 judgments since its creation. Each judgment is reproduced in several official sealed counterparts, a copy of which is sent to each of the states concerned. Virtually all the judgments of the court have been implemented. The court's second role is to respond to any legal questions put to it by certain UN organs and institutions. This procedure culminates in advisory opinions. Since 1946, the court has rendered nearly 30 such opinions, for example, on the legal status of Western Sahara and on the legality of the threat or use of nuclear weapons. The advisory opinion issued by the court in 2004 on the legal consequences of the construction of a wall in the occupied Palestinian territory has been one of the most high-profile in its history.
By 14 votes to 1, the United Nations, especially the General Assembly and the Security Council, should consider what further action is required to bring to an end the illegal situation resulting from the construction of the wall and the associated regime, taking due account of the present advisory opinion.
Unlike judgments, advisory opinions given by the court are not binding per se. It is for the United Nations organs or specialized agencies having requested an opinion to give effect to it or not by the means at their disposal. On occasion, a state and an international organization agree between themselves that the organization will request an advisory opinion of the court in the event of dispute, and that the two parties will treat the opinion as conclusive. Whatever the case, thanks to the court's legal and moral authority, its opinions carry great weight. Lastly, the consideration given to the court's advisory opinions by states and international organizations in their legal practice fosters the development of international law.
The court's function is to state the law and to settle disputes between states in accordance with international law. It cannot create new law as a legislator can. Its role is to clarify, interpret, and apply the rules of international law. Its decisions have significance which goes beyond merely the states and organizations directly concerned by the cases. The judgments and opinions delivered by the court often have a direct impact on the everyday lives of millions of individuals. On very many occasions and in all continents, the court has helped to diffuse crises, to normalize relations between states, and to reactivate deadlocked negotiations through the settlement of disputes by judicial means.
It is a great honor for me.
As the principal judicial organ of the UN, the court is an important cog in the international mechanism for seeking and keeping peace. In that capacity, the court very regularly hosts visits by heads of state and major figures.
The court is a judicial institution unique in the world. It cannot by itself prevent states from resorting to force, but recognized by all members of the United Nations, it now more than ever serves them as an invaluable instrument promoting peace. The International Court of Justice lends its support to the United Nations in achieving its primary purposes, which are to maintain and strengthen international peace and security.